Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business before this court is drawn here, if their attendance shall be heard.
Good morning, please be seated. First case for oral argument this morning is 757, People v. Park.
Good morning, may it please the court. Braden Gilman for Dennis Park. For today's argument, I hope to address point 2 unless there are other questions.
I'm sorry, Your Honor?
Do you want to sit up here? You can. Thanks.
I'd like to address point 2 unless there are other questions. Mr. Park was prosecuted for more than 16 months. The entire time he was detained pre-trial. When we look at the extent of the delay, I think there's cases in this department, namely People v. Brown, 117, Appellate Division 2nd, 978, where it was a 16-month delay post-indictment and this court dismissed. I think there's a number of other cases when you look at the Court of Appeals, People v. Johnson, 38, New York 2nd, 271. It's an 18-month delay. Both of those cases, the extended delay and pretrial incarceration really forced the client to plea, and that's similar to the case here.
Is this issue preserved in any way?
Your Honor, I don't believe that it's explicitly preserved. Mr. Park's attorney on the November 22nd, 2019 transcript, if you look at the motion to dismiss transcript on the double jeopardy issue, on pages 10 and 11, he made explicit statements about the prejudice to the defendant by this prolonged delay, specifically when we look at the 3 issues from the prosecution that caused the delay. First, the February 2019 delay for DNA analysis and the buccal swab. It's unclear that at that time, clearly we were ready for trial, and that was just on the eve of trial. Mr. Park's DNA was already in the CODIS system. It wasn't, there was 6 months that the people did not request the buccal swab, even though they knew in both cases there were sexual assault kits and they didn't request a buccal swab. Going to May of that year, 2019, again, the analysis, 509 pages of discoverable material were not given to the people until 40 days after the people had it, which was within 3 weeks of trial. Again, going to the mistrial, the people did not know that the serologist was not going to be at the trial. That seems like that's an error clearly attributable to the people. And then just going to the severity of the case, obviously we don't contest that this is these are severe charges that Mr. Park faced. However, I think if you look at the case from the Court of Appeals recently, People v. Regan, the court specifically talks about it's a sexual assault case where they dismissed, and they said that it also vindicates the interests of complainants when there's a fair and speedy process to prosecute these cases. And then obviously the client was detained the entire time, and we really...
Did the defendant request a mistrial?
The defendant did request a mistrial. However, I would point to the people. There's a case out of the Court of Appeals called People v. Minicone, where they say that the responsibility for protecting the defendant's constitutional right to speedy trial rests squarely on the people. Here, the people didn't know that the witness was going to be there. I think if the tables were turned, the defense attorney here didn't know that an important witness wasn't going to be at trial, I think that would be a clear error attributable to the defense. And then also, obviously, there's a confrontational aspect to that on the confrontation clause. And when that error, on both instances, when that error exists and that was brought by the people, I think that should be attributed to the people.
Okay. Anything further?
Unless there are any other questions, we'll rest. Thank you.
Thank you.
May it please the court, Alexander Shear for the people. I'll narrow my oral argument today to the second point, constitutional speedy trial. The Taranovich factors all in this case weigh in favor of the people. The the extent of the delay, less than 18 months total, this case was pending from the first incident date on July 11th of 2018 to the
What was the reason for the delay then?
As far as the delay, the length of the case, Your Honor, not necessarily any delay in
One of the
proceedings.
one of the Taranovich points is the reason for the delay.
Yes, any delay in this case was due to motions by the defendant. The defendant filed the omnibus motion, I believe, on August 1st of 2018. The suppression hearings were not held until April 10th of 2019. So all of that time, the court was in considerations of motions and deciding those motions. The first trial date was set for June of 2018, and that was adjourned due to the defendant's request. Defendant also filed at that time a severance motion, so that also was under consideration until July of 2019. Very substantial portion of that 18 months, the delay was attributable, or the time was attributable to the defendant. More importantly, this issue hasn't been preserved, really. There was no specific mention of constitutional speedy trial, and there's not really an adequate record here to delve into those issues because of the defendant's failure to make that motion.
Thank you.
Are there any questions from the court?
Thank you.
We'll rest on a brief. Thank you.
758, People versus Charles Williams. Good morning.
Morning, Your Honors, and may it please the court. I'd like to address the first 2 points in our brief, unless the court has questions about any of the other points. Starting with point 1, the prosecution makes a number of arguments with regard to this claim not being preserved, both of which are without merit. Firstly, this case is not governed by CPL 27010 because defense counsel was not challenging the process by which the jury here was constituted, and as a result, there was no opportunity to make a pretrial motion. We're talking about a situation where prejudice materialized during the actual process of voir dire when a juror injected extraneous information into the voir dire that was prejudicial to Mr. Williams. Secondly, CPL 2720, the peremptory challenge exhaustion requirement, likewise does not apply because defense counsel did not challenge an individual juror. Instead, counsel challenged a group of jurors, and although the third department in People v. Doherty indicated that in some circumstances a challenge to a group of jurors can be considered a challenge to an individual juror, the circumstances there are materially distinguishable in that in Doherty, there were a number of jurors who expressed an inability to be fair because they said they wanted to hear from both sides. That is not what we have here. We do not have a juror simply stating an opinion that suggests that the person cannot be fair. We have a juror who introduced evidence about having contact with Mr. Williams in her capacity as a law enforcement employee, a law enforcement agent, thus painting the entire jury panel. I would also note that it would have been completely futile for defense counsel to exercise 2 peremptory challenges here. The counsel had 2 peremptory challenges left, but there were 15 jurors on the panel. So had counsel exercised 2, there still would have been 13 jurors left, and the defense counsel still would have been there still would have been prejudice, and the exercise of those 2 peremptory would not have accomplished anything meaningful, and therefore to require under circumstances such as those in this case for a defense attorney to utilize all of his or her peremptory challenges would be, in my opinion, elevating form over substance.
Anything further?
Yes, Judge. As to the merits of this claim, the lower court essentially made two decisions. One, that this juror did not say that she actually had contact with Mr. Williams in her law enforcement capacity, and then even if she did, there was no prejudice. I would respectfully submit that the record completely belies the claim that this juror did not indicate that she had contact in her law enforcement capacity. The court confirmed with her that she worked in law enforcement, asked her if anything about that would impact her ability to be fair, and the juror said, I may have had contact with Mr. Williams, and then later on in voir dire, gratuitously indicated that it would be a conflict for her to sit on this jury and indicated that she should be removed. Our position is that the record clearly indicates that she had contact with Mr. Williams in her law enforcement capacity.
She said she may have. She never said she had.
That's true, Your Honor, but I think we have to look at both. I may have come in contact with the defendant in my law enforcement capacity, and then shortly thereafter, this gratuitous statement about I think I should be removed because it feels like there is a conflict. So it strongly suggests that she's privy to some information that renders her unable to be fair.
We'll look at that.
Thank you, Judge. And then with respect to prejudice, our basic position is that even though the jury would ultimately find out that Mr. Williams was on parole, there is a distinction between simply finding out he was on parole because he has a GPS bracelet on and having repeated contact with law enforcement. That repeated contact with law enforcement clearly shows or creates a more significant inference of criminal propensity, and therefore Mr. Williams was prejudiced by the lower court's denial of the request to strike that group of jurors. Moving on to point two, our position is that this is a unique case where this court should exercise its power to reverse the verdict as against the weight of the evidence. This was a completely circumstantial case that did not at all depend on witness credibility, and as such, this court is in as good a position as the jury was to weigh the evidence against Mr. Williams. This is a case where nobody saw Mr. Williams shoot the decedent. Our position is that there was also no evidence that definitively put him inside the building where the decedent was shot. The trial prosecutor and the people on appeal indicate that this cop's camera north of the location refuted the possibility that he may have gone down the driveway. However, if in my view, the video one is much too grainy and the camera is much too far away to, with any certainty, allow somebody to conclude that nobody went up or down that driveway. So that is a distinct possibility. Even if Mr. Williams was inside that residence, we simply do not know what happened. Was it an intentional shooting? Was there some sort of a scuffle that broke out? Did a struggle over the gun?
We'll look at that. We'll look at that very carefully. Thank you.
Thank you, Judge. The last point I would respectfully make is that in prior cases involving circumstantial evidence, this court noted that motive is critical. Not only is it material, but it is controlling. There was absolutely no proof whatsoever of motive in this case. And I would conclude by saying certainly there was evidence that pointed toward Mr. Williams in this trial. However, as the detective who testified indicated, most likely, the person in the video that was identified as Mr. Williams committed this crime. But this is not a civil case involving wrongful death where the standard is preponderance of the evidence. It's beyond a reasonable doubt, and the proof here did not establish Mr. Williams' guilt beyond a reasonable doubt. And as a result, this court should reverse the verdict as against the weight of the evidence. Thank you.
Thank you.
Elizabeth Dannon for the people. First, we would like to address the issue of the potential prejudice from the juror. In this case, we would like to direct your attention to this department's case, People v. Torres, 1780 3D 1046. It's very similar, where there was a potential claim of prejudice. A juror had remarked about a potential prior criminal history of the defendant. After some discussion in camera with both the defense counsel and the prosecutor, the defense counsel made no further objection and did not request a more complete curative instruction here. The defense counsel explicitly noted he did not want anything more stated about the case. He did not want any further prejudice. There was no unequivocal statement that the potential juror had actually had any contact at all. And with regard to the conflict statement, that was made with respect to the prosecutor's discussion about
It was about guns, wasn't it?
Yes, it was about gun violence, and it was in that context that she said that she felt she had a conflict. That juror was promptly removed. The court before and after the voir dire of that jury panel issued instructions on fairness. In the middle of the trial, also in another context, the court did individually poll each juror with regard to whether they could be fair to the defendant and only consider the evidence presented in trial. Also, in addition, as the defense counsel pointed out on numerous occasions, everyone surrounding the crime scene, around the place where the crime was committed, was known criminals. That was what police described them as. It did not prejudice the defendant in any regard to have, and it was known as well with regard to the parole violation that there was some, law enforcement history there. So with that regard, we would say that the prejudice was very minimal, and the court allowed the defense counsel to voir dire completely to make sure that there was fairness in the selection of the jury.
I think we understand that.
Okay, thank you very much. And with respect to the weight of the evidence, the people would rest on our papers and just merely state that we believe the evidence establishes intent, most beyond a reasonable doubt, if not motive. Thank you.
Thank you very much. 7:59, People versus Thomas Schrader. Okay, we're set.
Good morning, may it please the court. Stephanie DeGiorgi on behalf of the appellant. I'll keep it brief this morning and focus on point one. With respect to that point, this case essentially boils down to whether or not the appellant was justified in shooting Mr. Boone. I would submit, and I raise three separate subpoints.
So, excuse me, this is a road rage incident, right?
That is correct.
Okay, and I'm really just having a hard time figuring out when it's okay to shoot somebody in a road rage incident, if ever. And I guess the only time would be when the other person turns around and has a gun coming at you, and I don't see that here. So I do have a hard time to figure out, any possible justification.
So I would submit, you're absolutely right, Your Honor, as far as it's very clear in the case law that obviously if he had a weapon right there and displayed it, obviously deadly force can be met with deadly force. I would submit in this instance, you need to look at the totality of the circumstance. So it wasn't just one.
He no longer had the machete with him.
I'm sorry, Judge, what was that?
He no longer had the machete with him. It was gone, and he didn't, your client didn't see him with the machete there.
That is correct. There was no testimony that he had it at that, I'm going to say the last stop.
And the victim was going back to his vehicle, and the defendant shot him in the back 4 times.
Well, there was some conflicting testimony, medical testimony, as to where the bullets entered. So I believe there was some testimony that he may have been in the process of turning. But again, there was no, with respect to the incident.
Well, there is a video that was in evidence.
There was a video in evidence.
The video clearly shows he'd already retreated.
I think looking at the totality of the circumstances with respect to, there was 2 prior engagements between the 2 parties prior to this. He had displayed the machete in the car. They were going back and forth. Words were exchanged. The appellant was attempting to leave the situation. When he approached the vehicle the first time, he wanted to get a license plate. He wasn't looking to engage. They started to engage. So I think looking at the totality of the circumstances, his actions were justified. With respect to, his physical health, he was concerned. He was on blood thinners. He was in the hospital. His mental state with respect to, how he was physically feeling, there was a lot of testimony concerning that. So I would submit, at least with respect to point 1, the proof was not supported by legally sufficient evidence. Unless the court has any other questions on that, I'll rest on that. And then just briefly, with respect to whether or not the sentence was harsh or severe, I would submit the appellant had no prior criminal convictions. He was a productive member of society. He had a clear, consistent work history. And at the time that he was convicted, he had several physical ailments.
Right, but he didn't get the maximum, right? The maximum was 25 and he was given 18 years.
Yes, that's correct. Unless there's any other
His
questions.
victim was paralyzed as a result of the shooting, right?
Yes, I believe so.
Thank you.
Thank you.
Your Honors, Amy Hollenbeck on behalf of the people. I know the court is very familiar with the record, so I would just reiterate that the people's position is that this intentional shooting was unjustified, as demonstrated by the overwhelming evidence on either a subjective justification standard or an objective justification standard. The victim was shot in the back 4 times. He was unarmed. He was walking away from a confrontation. And yes, there had been earlier confrontations, but none of them rose to the level that would justify this on the 3rd occasion or 2nd occasion that the two interacted. Additionally, the sentence as imposed by the court, this case is a tragedy on a lot of levels. We recognize the fact that the defendant didn't have a significant criminal history. Nonetheless, as pointed out by the court, the victim was intentionally shot in the back, is paralyzed, and the defendant received less than the maximum sentence, I believe 7 years less than the maximum. So unless there are other questions, I would rest.
Thank you. 760, People versus Bruce Miles. Okay, Mr. Keene.
Good morning. May it please the court, Brad Keene, Mr. Miles. We assert that the trial court failed to inquire pursuant to PL 3030 sub 5. It's true that there is a 6-month time limit doesn't apply to murder in the first degree, but that doesn't mean 3030 sub 5 doesn't apply to this case, specifically where the people provided their certificate of compliance prior to filing the indictment. And then the second certificate of compliance had some serious questions related to the grand jury minutes and police disciplinary records. And really all of the supplemental certificates of compliance lacked any disclosure as to why the material was not provided timely, which is contrary to 245-51A. Unless the court has questions on that issue.
Well, I do. So you're saying that it doesn't apply to the murder first count? Is that what you're arguing?
I'm saying that a 6-month time limit doesn't apply, but the due process of 3030 and 245 certainly apply.
Okay. Thank you.
Then if the court doesn't want to find a 3030 violation, it can find it through ineffective assistance of counsel and the failure of counsel to make arguments and claims regarding the people's, what we would say the people's errors related to 245 and 3030. Finally, I'd ask the court to take a strong look at the summation in which the prosecutor overlaid 2 exhibits that placed a red line between the individuals. This made him a unsworn witness, which we assert was improper and really deprived Mr. Miles of a fair trial in that instance. Unless there are questions, then we'll rely on our brief.
Thank you.
Morning, Your Honors. Brad Osler for the people. I think as my opponent recognizes, there's not really an ability to dismiss this case on a statutory speedy trial ground because of the lack of time limit that would apply to this type of charge. To the extent, though, that certain other provisions of 3030 or 245 might apply in terms of discovery and due process, as I think he is correct in pointing out, I don't think the record reflects that there was any actual deprivation of any sort of due process here. The record is clear with respect to the people's discovery disclosures and the fact that there was no, gamesmanship or any sort of lack of due diligence here.
But there was some gamesmanship somewhere down the line, and that would be what happened during the summation.
So with respect to that, my position is that it was not an alteration of the evidence. So no evidence was actually created by the people.
Well, that's true. There were two, a compilation of two photos that had already been in evidence. However, there was some alteration, a lighting sort of alteration. And, I sometimes have an issue when I want to say you shouldn't have done that, okay? Because it wasn't necessarily fair. There could have been some, objections raised to that if you ran it by counsel before you did it, but that didn't happen here. And then an entirely new exhibit is put out there that no one's ever seen, okay? And so then we have to get to the point that we say, well, did it really deprive him of a fair trial, blah, blah, blah. And sometimes it doesn't, but I still want to say you shouldn't have done that. And it's hard to, write that on a piece of paper, everything's, but I guess I made my point with you.
Don't do it again.
I certainly understand that. And I would have a harder time standing here with a straight face defending what was done here if it weren't for the fact that nothing like this was sent back to the jury. So I think to the extent that it was something that we should not have done, the effect, I think, had to be somewhat minimal. It was a momentary presentation to the jury, and otherwise it's something that, to some extent, they could have done in the jury room with the actual exhibits, just kind of laid them.
Well, that was what, right, with the actual exhibits.
Right,
the ones that are in evidence.
Right. And I mean, they would, certainly the jury would be entitled to do that on their own and compare the heights of the two individuals depicted in the images. And so to the extent that this was just that, essentially, I don't feel it was actually error. But I understand, I take your point, Your Honor.
Thank you.
If there's no other questions, we'll rest.
Thank you. 761, People v. Colin Rideout.
Morning, Your Honors. Kathy Reardon on behalf of, Colin Rideout. Initially, the severance should have been granted in this case. Joint trial resulted in unfair prejudice to Mr. Rideout, substantially impaired his defense.
Was that preserved?
It was preserved. Initially, he brought an omnibus motion where he reserved his right to bring later motions. He did not request severance right off the bat. He thereafter did file a motion, and the court did rule on it. There was some discussion at the pretrial conference. Thereafter, he moved for severance after Kish's testimony, Laura and Tucci's summations, and the DA's summation. And under McGuire, this court has the ability and the review of the benefit of the full record to make that determination. He joined in with everybody else who had made severance motions ad infinitum throughout the
And we've
this
heard
trial.
some of those on appeal.
Yes, he did, yeah. This wasn't harmless error. This is a substantially different case than co-defendant Laura Rideout's case. The evidence against Mr. Rideout in terms of the murder was not overwhelming. The testimony here on cross-examination from some of the witnesses did in fact reveal new information that did not come out on direct. And I've reviewed that in my brief. Just briefly, a couple of issues. At the opening for Alex, Alex's attorney basically said the police did a great job, the investigation, the review of all the evidence was fine. We have no problems with it. That flew directly in the face of Colin's defense. Basically, you had to disbelieve one to believe the other. On Laura's case, for instance, Mr. Weaver, he testified only that he saw a shovel in the grass. Laura's attorney, in fact, established the proximity of that shovel to the vehicles, and that's what the people claim was the shovel that Colin purchased at the Walmart previously. Mr. Harshfield at the Walmart, he testified only regarding the video of the purchases. Laura's attorney highlighted all of the supposed actions by Colin as he walked up and down the aisles and things of that nature while she was supposedly in the bathroom. With regard to Miss Drew, the sister, she testified that she saw Colin driving in the area, which, by the way, was never in her deposition. She didn't extract any other information. Laura pulled out the fact that apparently he was actually at the house and she missed him because he was picking up the kids. Kish, which we have all sorts of problems with his credibility, but he basically said through Laura there's no other explanation for the saturation of the blood on the jeans and the spatter issue. The summations were just an all-out war between all these parties, but especially Laura. And for instance, she says there's no proof that Colin was only cleaning, can't beat incriminating evidence, blood on the clothes had to have happened during the murder, and the spatter on the jeans was conclusive. This was not only imprudent to deny severance, but it basically robbed Mr. Right out of a fair trial.
We'll look at that very carefully.
In terms of the weight of the evidence and somewhat of the legal sufficiency, this is a circumstantial case. Again, we submit that this is a substantial difference from co-defendant Laura's case. In Carter, and I know this court is familiar with that case, basically where the people's case is based entirely on circumstantial evidence, motive becomes not only material but controlling. Laura had every motivation in the world. There was a contentious divorce, custody battles, fights over supervised visitations. She was in violation when she was in the house.
We're aware of all that.
Right. And just one last thing with regards to her. This court mentioned in another case, and it happened to be Carter, brutal killing conceived with great malice, and that was proof of motive for Laura. Colin had no motive. He was leaving, he had become engaged, he was moving to Michigan with his fiancée, he had no part in the divorce, he had no issues with the custody issues. So he had absolutely no motive in terms of the, and we're just talking about the killing here, not the tampering. And I think we have to at least acknowledge on the record that even in the PSI, he indicates that there was some involvement in terms of the cleanup afterwards. In the court's decision on Laura's case, amongst some of these other issues, they talk about the things that were found in the house. In Mildenhall, in her bedroom, the car keys, the tarp, the bungee.
No, we're aware of all that.
Right. None of that applies to Colin. There was no evidence that he was involved with any of the murder weapons. In terms of the DNA and the forensics, again, there were questions about how well the police really did with regard to this. There's blonde hairs all over the place that were never analyzed. And they said even though that there would be some issues with it, those could have been analyzed had they taken the effort to do it, but they didn't do it. And finally, in terms of Mr. Kish, two things with regards to him. Talking about the wiping and his credibility, essentially to say, well, they had to have wiped this way and that's why the blood ended up where it did, instead of going up and down or horizontal. But more interesting is the spatter, because he says Colin must have been in close proximity to the murder because he had two small dots of blood spatter on the back of his jeans. Well, interestingly enough, they never testified what those two small dots were. So proof never came out that in fact those were blood. Based upon all that, we would request that the court reverse and vacate the conviction on that. Just briefly in terms of the sentencing, we've got a young man who had no priors. He was college educated. He had come home to take care of his family, but he was moving on. Some of the other cases in this court, including Jeffords and Rankin, where the sentences had been reduced. He was given 25 to life and 1 1/3 to 4 consecutive on both of the tampering charges. We're requesting that this court consider reducing even to the minimums and to run all of those sentences concurrently to each other.
Thank you.
Good morning. Marty McCarthy for the people. It's clear the court is well aware of the facts. This is the third argument of these defendants. With respect to the severance issue, the severance issue is not preserved. When you look at the severance motion itself, the severance motion simply said that this defendant's defenses were in conflict with his co-defendants, not vice versa, not what he's arguing now on appeal. When you look at the specific instances that the defendant has now brought forward in terms of his severance argument, there are no contemporaneous objections to those instances in which the defendant now points to as grounds for severance. There was only one generalized objection made by defense attorney to Kish's testimony, but that objection did not go to the grounds that he now wants to attribute on appeal. So the issue is not preserved. When you look at the merits of it, the court's already looked at the merits of this through the lens of Laura Rideout. I'm not going to belabor the point. I think I set that clearly out in the brief. But when you look at the merits, the defenses were not inconsistent with each other. The defenses, in essence, were basically the same defense. That unknown other family members were the ones that killed Craig Rideout. But these particular defendants didn't do it. It was a finger pointing, but not at each other, but at other unknown assailants who may or may not be related to Craig Rideout. That was the essence, the core essence of all three defendants. Did you have a question, Judge?
I do. What about, Ms. Reardon brought this up in one of our earlier cases brought up as well, concerning the circumstantial cases and the People versus Carter, where motive is required or needed to be proved. What about this situation? How do you respond to Carter?
Well, in this case, when you look at the motivations of the actors, you don't have a scenario where you have one actor. You have a scenario where you have multiple actors, and those actors are sharing the motivations of each other. Because again, you can be an accomplice to somebody else's motive. So even if Laura Rideout had a motive, Colin Rideout certainly was an accomplice to that motive. He shared that objective with her, as is depicted on the evidence with respect to them going to getting the cleaning supplies beforehand from Walmart, the actions after when they go to Walmart again, and they drive the cars out to the remote location in Yates County, they dump the bodies, they take the evidence from the murder scene, Colin and his brother Alexander, they drive to the Devil's Bathtub, they toss that murder evidence into the Devil's Bathtub, which is kind of a funny name for a place. When you look at the fact that they can share her motivation, doesn't mean he has to have his own independent reason for why he wants to kill his father. He can simply share in her motivation, which the evidence clearly depicts he did. And I would submit the sentence here was definitely not harsh and excessive. This was a very heinous, calculated, brutal slaying of an individual. And had that farmer not been walking by in Yates County, he may have got away with it. So I submit the sentence is not harsh and severe. If there are no other questions.
Thank you very much.
Okay, thank you.
762 People v. Andrew Stobie. Do we have issues?
We have Mr. Keene. We're just trying to get his camera and microphone back on. Thanks, Judge.
Should have it on speed dial.
Yeah, you should have had this ready, Mr. King. Come on.
I was the court was frozen. Can you hear me now?
Yes.
Okay. I apologize. Brad Keem again. We assert that the trial court erred in denying defense counsel Antonacci's speedy trial motion on timeliness grounds. A speedy trial motion should be made prior to the commencement of trial or the entrance of a guilty plea. There's no requirement that the motion be made immediately or the filing of the first omnibus motion by defense counsel DeRoberts. It's true that defense counsel Antonacci failed to file the motion, as people stress, 19 months after the arraignment. But defense counsel Antonacci didn't enter the case for 17 months. That defense counsel was able to file this motion less than 3 months into a case the people repeatedly in their brief referred to as complex. It involves 76 charges and 22 co-defendants, I think is laudable. And
So, Mr. Keem, so is this issue preserved?
I believe it is. And if it is not, Your Honor, I think the problem then lies with ineffective assistance of counsel. And I would ask the court, if it does find a preservation issue, to either look at it in the interest of justice or look at it in terms of the aggregate issues that are brought forth in the brief.
Okay, I have a second question, okay? Are these issues, these speedy trial issues, are they forfeited by the guilty plea?
We would argue that they are not, and if the court elects to state that they are forfeited, then we'd ask for interest of justice jurisdiction if it finds it able to do that even.
Okay.
Thank you.
Yep, thank you.
Good morning, Your Honors. May it please the court, Sheila Bautista for the people in this case. Your Honors, the defendant failed to preserve his 3030 complaints on appeal, and there isn't a proper record for the ineffective assistance of counsel claim either. This case exemplifies why it's important for the defendant to preserve issues to create a proper record for this court to decide the issues before it. With respect to the motion that defense attorney Antonucci made before the court, that was not a 3030 motion. It doesn't cite 3030. It doesn't allege that the people failed to act with due diligence, and it doesn't even specifically seek to strike the certificate of compliance, which is what a 3030 motion does. This case is akin to this court's decisions in Smith and Hickey, where those were both cases where there were motions to strike the certificate of compliance, but they weren't specifically 3030 motions. So that's also what happened here. Based on the defendant's failure to make the specific complaints under 3030 that this court needs to decide, this court doesn't have the proper record to determine whether or not there were any 3030 violations here. To answer your question, yes, by failing to file that 3030 motion, the defendant forfeited his rights to complain about the timeliness of the people's disclosure when he pleaded guilty and waived his right to trial. When he waived his trial rights, he waived all his trial rights, including his right to complain about the timeliness of the discovery the people were to give him so he could prepare for that trial. And with respect to the ineffective assistance of counsel claim, the defendant did not file a 44010 motion. Without that 44010 motion, this court does not have the proper record to determine whether there was a clear-cut, dispositive issue that the defense attorney failed to raise in support of a 3030 motion.
Thank you.
Thank you.
766 Erie Insurance Company versus Children's Palace Child Care Center, Inc.
Good morning, Your Honors. May it please the court. Brandon Snyder on behalf of the plaintiff, Appellant Erie Insurance Company. As the record before this court shows, there was a massive fire in a commercial plaza. The origin of the fire is not really disputed.
We know all that.
So what it boils down to, we have our claims against the daycare owner, Children's Palace, and our alternative theory of liability against the manufacturer of the computer and what we believe to be the power cord. So first I'm going to start with Dell and go through some of the issues here where the court erred. So Dell's position is that it argued that the power cord may not have caused the fire, but the trial court found that we met our burden on that. The real issue is whether or not Dell manufactured.
Didn't Dell argue that they didn't manufacture this power cord?
That is the crux of the argument, Your Honor. And I believe we can boil this down to two issues. First,
was that challenged below at all? I mean, they indicated that they don't use that type of metals to manufacture it.
Yes, Your Honor. We did challenge it before the trial court. I think the main issue here is Dell presented 3 affidavits. An affidavit of Mr. Vickers, an affidavit of Mr. Dempsey, an affidavit of Mr. Voigt. As it relates to I'm actually going to go backwards to front. Mr. Vickers was brought as an outside cause and origin expert. He's the only one that actually inspected the cords after the fire, and his affidavit is very clear. These cords were damaged so severely, accurate testing could not be done. Now, when we go to Mr. Voigt, the Dell employee, there's nothing from him that says that he inspected the cords pre-fire or post-fire. Now, he looked at photographs, but Mr. Vickers said that there could be no reliable testing and all that was left were photographs. But Mr. Voigt then says that you cannot actually tell whether or not this is a Dell cord just based off of photographs. Mr. Voigt also testified that the power cord came either from a Dell-owned factory or a Dell's own factory or a factory that it owned. But either way, a separate manufacturer would have created this power cord, and Dell has specifications for United States power cords, but different specifications for power cords in other countries. These are all assembled in one factory under one manufacturer.
So you're speculating that this cord came from some other country?
No, they were all made within the same factory, Your Honor. I apologize for being unclear. So Dell owns this factory, but it makes power cords for the United States, and it makes power cords for other countries. They're all made in one factory, but this manufacturer...
So they make power cords for one for U.S. or one for another country, is that what you're saying?
Theoretically, I don't know the exact number of countries, but there's different specifications for each country. So, that manufacturer never produced an affidavit here. And Mr. Voigt said, based on the photographs, I can't tell you whether or not this is a Dell photograph, and that's all he relied on because he never inspected these. But I think the other part of this, too, is that when we look at the affidavits, Dell is telling us that we did not manufacture this power cord. But the case law that is outlined in our briefs is very clear. You need to attach some supporting documentation to these affidavits. Right, we would like to see the actual UL standards, the testing records, the sales records, things of that nature. We'd also like to see exemplar testing and Dell point to another entity that may have actually manufactured this. None of this is present in the Dell affidavit.
To challenge it, though, Mr. Tutt was your client's or the appellant's expert, right?
Yes, Your Honor.
And the court find that affidavit was conclusory and lacked evidentiary value, and he could not offer any evidence to a reasonable degree of certainty that the fire either occurred in that room or the power cord was the one that established the cause of the fire, or that Dell manufactured this power cord.
With all due respect, I would separate those into two separate issues. Mr. Tutt was a causation expert. Now, he did opine that this was a Dell power cord, and the trial court did take issues with his affidavit. But as this court is aware, the party opposing a motion for summary judgment is held to a more lenient evidentiary standard. But nonetheless, Mr. Tutt submitted an affidavit where he swore to the accuracy of his report and attached his signed report. But in terms of whether or not this was Dell, the trial court bit hook, line, and sinker onto these affidavits. But again, these affidavits lacked anything to back up.
Look at that.
But also, in terms of the power cord, there was no manufacturer pointed to that may have caused this as well. But then I think, so that relates to the prima facie burden. But when we actually go to the testimony before the trial court, we have Mr. McCullough stating that he went to Office Max and purchased this brand new Dell Optiplex 720 unit. The Dell employee, Mr. Voigt himself, testified that Dell packages these power cords with the computer when they leave the Dell factory. Mr. McCullough states he went to the store, Office Max, a reputable store,
And he bought it.
purchased it, and sets it up just as it was. There was no modifications made to these cords, nothing was swapped out, nothing of the
As
sort.
far as he knows.
As far as he knows, but that's all that's in the record before the court. So with that in mind, I would say that at a bare minimum, based off of Mr. McCullough's testimony and the lack of evidentiary support for these Dell affidavits, there's at least an issue of fact whether or not Dell made this power cord.
There's no evidence that the power cord caused a fire, though.
On that, I believe the parties actually, many of the parties agree before
Does
this
the fire
court.
inspector say it's undetermined?
The municipal fire investigator said that it was undetermined, but we cannot rule out the computer equipment. Now, as it relates to Mr. Tutt, he pointed to this defective power cord and the components within same, they are so below what is required that this would have led to the fire.
Right, but then, and to challenge that, the Dell's experts or affidavits indicate that they don't manufacture these type other than UL standard, to UL standards, and this apparently was not a UL standard.
Yeah, with all due respect, Your Honor, I think that's a fairly self-serving argument.
Questions, yeah. With respect, I don't like
we can't, we can't be held liable because we only make the right cords.
Okay, yeah, we'll look at that, we'll look at that issue. Do you have anything further?
Yeah, so obviously we have alternative theories to the case here. So we have Children's Palace and we have Dell's. With Dell's, we already went through that.
On Dell. Why don't you turn to the next
When
one?
we turn to Children's Palace, their argument's pretty clear. We didn't have notice of the defective condition, and we didn't create the defective condition. As it relates to that, I think the trial court erred on both fronts. We can take Mr. McCullough's testimony himself. He said that there's an electrical room that he hooked up these monitors to. He said this was a mess, it was a maze of wires, the electrical room was always causing issues for the plaza block, power was always going out. So then he states that he hooked up these computers, inviting this hazard onto his property, that he admitted in his interrogatories he had noticed of this defective condition. But that's just the one hazard we're talking about here. If the record for the court's pretty clear on this as well, what he actually plugged into the RPT receptacle, there were sliced wires. These were in his unit. He's hooking it up to this. This is a child's daycare center that's held to a higher standard here. And then he wants to feign ignorance when the place burns down. We also cited to a case, Weller, that stands for if an entity is under a duty to investigate or perform regular inspections, that issue of notice actually is presumed. And we cited to, it's NYCRR 418 in our brief. This is a child's daycare center. It was required to perform regular inspections. So that's the notice prong of this, but also as it relates to the creating of the defective condition. Again, there was spliced wires on the inside of the unit. He hooked it up to the existing known hazard on the other side of the unit. As it relates to that, we'd say we satisfy both prongs. At least an issue of fact relates to both of those, Your Honor.
Thank you.
Thank you.
Good morning, Your Honors. David Tennant on behalf of Dell. And I would just start off by correcting the record with respect to what the record shows with respect to the deficient alleged by plaintiffs in the case with respect to the power cord. They identified two different aspects, one being that the plug blades were nickel-coated aluminum, which they say is the wrong material, and the other is that the conductors, the wires, were undersized, underrated, and specifically said that they didn't meet the 18 American wire gauge standard. So it's actually out of plaintiffs' experts' mouths that we get the articulation of what they think is wrong with the power cord, notwithstanding the damage that the power cord suffered during the fire, and trying to figure out how many strands are there. That's their articulation of their theory of the case. And in terms of where that's set forth, it's R630, R279, R224, and R663 are all places where they particularly set out their theory of the case. Now, it's plaintiff's burden to show that it's reasonably probable that the Dell power cord was actually involved in the at-issue fire. They have to show that the remnants are a Dell power cord. And they can't do that because, as Justice Montour was saying, we don't make power cords with aluminum plug blades. We only make power cords that have the 18 AWG thickness of the power cords. So this is just like the cases that we've cited in our brief, where we have in Whalen an exploding light bulb, where the expert, the record shows that the at-issue bulb was different from what the manufacturer supplied. The at-issue bulb in Whalen was a 3-filament bulb, and the manufacturer was a 2-filament bulb. So, and you go down those different cases that are cited in our brief that the trial motion court relied upon, it's all those same kinds of identification of something objectively different about the at-issue offending product and how the manufacturer can come in and say, that's not our product.
I understand that.
All right. Thank you, Your Honor.
Good morning, Your Honors. Patrick Mackey on behalf of the defendant Children's Palace Child Care Center. An important aspect of this appeal, Your Honors, and I'm sure you're aware, is that the expert witnesses in this case, especially the plaintiff's expert witness, stated that the cause of the fire was this underrated power cord, and as Mr. Tennant identified the reasons of why it was determined to be underrated. And there's no dispute, the fire was caused by this power cord that overheated. Thankfully, it was during the evening or overnight where no one was present in the facility. But there's no dispute that it was the cord that caused the fire.
The fire inspector didn't say that, did he?
Fire inspector in the report said it was essentially undetermined. Right.
But you're saying it was the power cord.
Other experts who included Children's Palace experts, the plaintiff's experts, have said it was the power cord. And it was because it was underrated and prone to overheating because of the...
You're claiming it's Mr. Tennant's client's fault.
Well, not necessarily. It's the manufacturer of the cord. I don't know who made the cord.
It's Dell.
The most important thing I know is that my client didn't make the cord because my client's a child care center. It's a daycare center.
But more importantly, from your client's point of view, is the wall outlet, which is known to be defective, is not pointed by anybody to be the cause of the fire.
That's exactly. That's an important factor because I think what the plaintiff in this case is doing is grasping at straws of trying to find a reason to pull my client back into the lawsuit. And one of the reasons is, supposedly this outlet, this receptacle was improperly wired. Again, it's a daycare center. My client is not an electrician. He didn't install the receptacle. The building was presented to him as a unit for him to lease. He is no way, or my client's no way capable of determining whether an outlet is faulty or not, like anyone else who is not an electrician would be able to. They grasp at straws by saying, well, there was this maze and mess in the electrical room, and admittedly my client said when he saw the electrical room, he saw it as a maze and mess. Your Honors, if I looked in an electrical room, I would say the same thing. There's nothing in the record that says this, quote, maze and mess was actually a faulty electrical room. There's nothing in the record that says there was unsafe conditions in that electrical room. It was simply my client who owns a daycare center saying, I looked at it and I saw it as a mess. For all we know, everything was in there, was properly done, and it was entirely safe. There's this issue about that the facility itself was not in a safe condition, that it wasn't following safety codes. Again, there's nothing in the record that says there was any violations of the safety codes in that facility. And my client testified to the opposite. Before he opened for business, they had to be inspected by the county, and they passed the inspection. To remain in business, they had to be annually inspected by the county. For 3 years they were in business, they never had issues with the inspection. So there was nothing showing that there was any type of an unsafe condition in the facility itself, in the daycare center. And there's no record of it existing in the electrical room, no matter what my client said. So they're grasping at straws, like I said, to try to find a way to bring my client into this case. And at the end of the day, we're looking at an underrated power cord that overheated. And like I said, my client
It has nothing to do
has
with
nothing
your
to do with
client,
that. And at the end of the day, and I think this was at the end of our brief, is it's important to look at who's not in this case. Office Max was never named as a defendant in this case, even though they're the one who sold
We
this
don't have to
cord.
look at who's not in the case.
Right.
We just need to look at who is in the case.
Sure, Your Honor, but
We
I
got
guess the
enough
point I
on our
make is
plate.
Children's Palace shouldn't be held accountable for what Office Max failed to do. Thank you.
Thank you. 769 Lilydale.
May I respond, Your Honor?
No, you may not, we don't have any response. 769 Lilydale Assembly versus Robert Ruther. What's the matter?
There's a second case along with this one.
Oh, I'm sorry.
By Harleysville Preferred. The defendants are the same.
Oh, I'm sorry, I thought we, okay, you're right. Do we have nobody?
Yeah, nobody's here, I don't.
Okay.
Right? Are you, is that what you wanted to argue?
No, Your Honor, I'm not here on behalf of the.
That's what I thought. Okay, so, no.
They were supposed to be arguing together, but I don't see the other counsel.
Right, we're missing one.
Yeah. So, do you want to respond or?
We didn't do the court.
I thought we were arguing them all together.
No, we didn't manufacture the court.
No, at the risk of, extracting defeat out of the jaws of victory. I just wanted to point out that in their brief, they argue there was some type of obligatory duty to inspect the products before they went out. Obviously, the problem here is the products were sent out, left Dell's control 3 to 5 years before Office Max sold the computers to Mr. McCullough. And these were Optiplex 760 computers that were manufactured between 2008 and 2010. There's no way to go back and look at thousands of records. We had no way to trace the sale from Office Max to Children's Palace Center. So there was no way to actually get a hold of inspection records. But obviously, every single product that goes out from Dell gets the full treatment in terms of being inspected to make sure it contains Dell products.
Thank you.
Your Honor, again, Patrick Mackey on behalf of Children's Palace. With respect to the appeal by Harleysville Preferred Insurance, I'll just rest on the arguments I previously presented.
Thank you. Now 769, Lilydale Assembly versus Robert Ruther. See, it was good exercise, though. You had to come up and down a couple times, right?
Are you saying I need it?
No, I wasn't saying that at all.
I think it was implied towards me. Good morning, Your Honors. May it please the Court, Nicole Master-Sinkway with Barclay Denman, counsel for Appellant Lilydale. The question before this Court is a simple one of contract interpretation. Whether the respondent and Lilydale agreed to, or I should say required respondents to abide by Lilydale's bylaws and rules and regulations in exchange for a 99-year leasehold interest on Lilydale grounds.
Well, your agreement, your bylaws, and your rules are silent regarding annual business and license fees. There's nothing that indicates you're $1,000 a year for a license fee in any of those instruments, is there?
Respectfully, Your Honor, I think that's actually a little bit outside of the scope of this appeal, because the appeal is really narrow in scope to page 8 of the record, where the court stated that the indentured agreement is not clear and ambiguous as to require the respondent to abide by the rules and regulations of Lilydale. And that's really what's in dispute today. And it's problematic for Lilydale, not just in this instance.
So the
but
rules and regulations don't identify a $1,000 a year license fee.
I respectfully disagree with that, Your Honor, but the indentured agreement does require that respondent follow the rules and bylaws, and the court stated that they did not have to. And that's what's the problem, is that that decision not only affects here and the indenture agreement with respondent, but affects every single leasehold interest. So the decision itself and the language that is used has far-reaching implications outside of this case. If we look at the indentured agreement, it says...
Couldn't Lily Dale just merely modify or amend their bylaws, laws, regulations to identify that a $1,000 license fee will be required annually?
Your Honor, I think if we look at the rules and we look at the bylaws and regulations, it does say that there's intent to be able to charge fees for people that are operating and financially benefiting from...
There's no doubt that Mr. Ruther is benefiting from being have his lease and being able to operate his business. That something owl, isn't it? That's the owl. I mean,
The owl's nest.
Owl's
yes,
nest. I was going to say nesting owl, but I was wrong. He's benefiting, obviously, but there's nothing that there's an interpretation. Whether or not there's an interpretation that there's a license fee in your bylaws or rules or regulations or agreement without identifying specifically. I mean, that's a question why we're here,
the
right?
rules and regulations do actually require that Lily Dale be able to assess a fee, and Lily Dale has interpreted that.
And he
to be
paid the
able to.
original fee, didn't he?
There is one fee, but there's several fees. It's an annual fee.
But is it specified what the annual fee is?
No, I think that's a decision that Lily Dale is able to make
So
as the
do
board itself.
all the members there have a $1,000 license fee, or some $750, some maybe $5, some maybe, you know?
So the guest house fee is $1,000, and it doesn't just apply to respondent here. But Your Honor, I know that we're talking about the rules and regulations, but really what my client is concerned is about the language of what the lower court has decided, and it's saying that the indentured agreement does not require that any leasehold interest be subject to the bylaws and rules and regulations. And
Well,
that's
if
problematic.
it's ambiguous, isn't it your responsibility to determine that show that it's not ambiguous at all?
Respectfully, Your Honor, I don't know how it's ambiguous with respect to the indentured agreement. And I understand that we have a disagreement with respect to the bylaws and rules and regulations, but what we're talking about is the indentured agreement, which is the lease agreement that states that respondent and others can have a 99-year leasehold interest. And the court's saying that's not clear enough. But the indentured agreement says that respondent is taking the premises subject to the bylaws and rules and regulations, and says that it cannot act contrary to the bylaws and rules and regulations. So I understand that there's a disagreement on the rules and regulations and what they stand for in the bylaws, but our issue really goes before that, and that it talks about the indentured agreement. And if we look at the indentured agreement, it's quite clear that it says that the respondent takes the property subject to the bylaws and rules and regulations, and that's all that we're appealing here today.
Okay, we'll look at that very carefully.
Thank you, Your Honor. And I just want to emphasize that it really is problematic for Lily Dale, the way that the court made this decision. It's really broad in scope, and that's really why we're here today.
You made that point very clear.
Okay, thank you. And then the second part, Your Honors, that I want to talk about is that the court also stated that Lily Dale is not required to prove that the respondents read or understood, and I believe that's contrary to the case law. And the case law really stands for the proposition that when an individual becomes a member of an organization, that they are entitled to abide by the rules and regulations of that organization. It's intertwined. So the contract and the rules and regulations are intertwined in this individual's membership contract. And that's what the case law stands for. So I think that by the court saying that Lily Dale had to provide or prove that the respondent received a copy of the bylaws is really contrary to this. And I think it would really, it's really grounded in practicality. So any other kind of interpretation of this would allow any member of an organization to simply say, I didn't know what the rule was, therefore I don't have to abide by it. So the common law, or I should say the established case law, is really kind of grounded in that common sense and practicality. I also feel inclined to address that respondent made several arguments about alleged procedural deficiencies. Unless anybody has a question about that, then I think I'm going to refer to the papers, as there's ample case law to kind of define that there is no prejudicial impact on a respondent and wouldn't really impact the decision that the court is being asked to be made here.
Thank you. Anything further?
No, Your Honor, I think for the rest of the arguments, we'll rely on our papers if there's no more questions.
Thank you.
Good morning, good morning, good morning, good morning, good morning. Robert Ruther, pro se, scared out of his mind.
Aren't you basically relying on the fact what counsel just indicated that, hey, I didn't know, so I don't have to pay. So I don't have the bylaws.
Absolutely not.
Well,
We had a copy of the bylaws, Your Honor, but
Didn't you pay a license fee of $750?
No,
At
sir.
one point in time?
no, sir.
You did not?
We paid
So
a
how long you
one,
been there?
we
What?
paid a one-time registration fee,
And how much was that?
$750. There is no mention whatsoever in our contract, in the bylaws, in the rules and regulations, in the indenture agreement of any annual guest house licensing fee. I mean, I
But
can
you
read
paid a
through.
licensing fee in 2019, too. You
We
paid
paid it
$1,000.
in 2019 because we simply did not know that we shouldn't pay it. We
But
relied.
that was in addition to the $750 application fee, right?
No, in 2018, we only paid the registration fee.
Right.
2019.
And then in
In
2019, you paid a
2019, they came back and said, you
licensing
need to
fee.
pay this $1,000 fee. We did not know. We don't know. Come 2020, that's
You
when
can't just say, we don't know, we're going to pay it one time, and then just say, well, we don't know, we're not going to pay it again. How is that? You're getting a benefit here, aren't you?
We
I mean, the Owl's
paid-
Nest would not exist but for the fact that you have the ability to be at Lilydale.
When we applied to operate the guest house, it was clear in our contract and in Article 4, Section 4, that we were required to pay an appropriate fee. And the appropriate fee that is identified in writing was a $750 registration fee.
But again, you paid a license fee in 2019, you just said that.
We did pay that because, sir, we did not know any different, and we were told by the board that if we did not pay this fee,
Did you bring an action to recollect that fee?
I didn't even know we could. All we know is in
You
20...
say, well, gee, I paid that, I guess we weren't supposed to pay it, you owe me $750, because I don't have to pay that. You didn't do that, did you?
We did not, we know, in 2019, we did not ask for our money back, we paid it.
2020, you didn't ask for your money to pay it back, right?
We didn't pay in 2020, Your Honor.
No, in 2020, you didn't ask for that $750 back, right?
How could we ask for the registration fee
The
of...
question is yes or no, did you request the $750 back?
No, because it's an appropriate fee. It's an appropriate fee.
Are you saying you have a claim to that? You have a right to have
No,
that return?
no.
Why? Because you paid it, because it was a license fee, you paid in 2019?
It's not a license fee, Your Honor, it's a registration
You
fee.
indicated you paid, in 2019, you paid a license fee.
We did because we
Okay,
didn't know better.
Let's go on to the basis of your argument, because we've already agreed you paid 2019 a license fee. Go
That's
ahead.
true. Plaintiffs and their lawyers repeatedly make the argument that the Ruther family should be forced to abandon the family home and be expelled from the Lilydale Assembly grounds because the Lilydale Assembly bylaws and rules and regulations...
Let me ask you a separate question. If Lilydale and their board goes back today and amends the bylaws, regulations, rules, et cetera, to include a $1,000 license fee, do you object to pay that?
If they went through the rules and regulations protocol to
And
amend...
They amended the rules and regulations and put in there a $1,000 license fee annually. Would you then pay that?
If that's in the rules and regulations, yes, sir, we would.
Okay, go ahead.
They also make the argument that the Ruthers knew or should have known what bylaw, rule, or regulation has been violated because they are assumed to have read and understood the Lilydale Assembly bylaws and rules and regulations, and therefore it is not necessary for the plaintiffs and their lawyers to have to tell the Ruthers exactly what bylaw, rule, or regulation has been violated. This assertion has been modified to say that, in fact, it was Article 4, Section 4, that was violated by the Ruthers' refusal to pay an unwritten and inappropriate annual guest house licensing fee. We have now read the Lilydale bylaws and rules and regulations, and we feel confident that Judge Hanlon has also read these documents. We are unable to find any mention in any of the documents, or even in our indentured agreement, of any annual guest house license, of any protocols for issuing or applying for an annual guest house license, or of any fees required to obtain an annual guest house license, or of any requirements to pay an annual guest house licensing fee. In summary of our searches for this licensing fee, we found that 1, an annual guest house license and licensing fee and the requirement to pay one do not exist in our bylaws. They do not exist in our rules and regulations. They do not exist in Article 4 of our rules and regulations. They do not exist in our leaseholder's contract, the indentured agreement. They do not exist in our business contract, which is contained in the rules and regulations, Article 4, Section 4. This contract was signed by the Lilydale Assembly Board Secretary, signifying that all contractual conditions had been met by the Ruthers, including the payment of all appropriate fees, to wit, a one-time registration fee. The annual guest house licensing fee is not an appropriate fee, as it is not authorized by anyone, anywhere in writing, including the signed contract between the Ruthers and the Lilydale Assembly authorizing the Ruthers to operate a guest house on Lilydale Assembly land. Plaintiff's argument that this non-existent license and demanded fee is valid and enforceable because it is somehow, in their wording, associated with a contractually authorized operation of our guest house has no merit whatsoever.
I think we have your argument.
Pardon?
It's not in there.
And it's not in there.
Okay, we have your argument.
Should I finish? A couple more minutes. Rules and regulations, Article 4, specifically state that businesses that provide direct services to the Assembly are exempt from any fees. All Lilydale guest house owners provide a direct service to the Assembly, as the Assembly does not have the means on its own to house and feed the many, many visitors who wish to stay overnight or for extended stays. Rules and regulations, Article 15, spells out the procedures to modify our rules and regulations. Plaintiffs and their lawyers have failed to even acknowledge this clear path for authorizing a guest house licensing and fee.
I think we understand your argument.
Plaintiffs have failed to provide any evidence that the Ruthers have failed to abide by Lilydale's bylaws and rules and regulations, which is the sole issue of this appeal. Because of the aforementioned items, and based on Judge Hanlon's 2 prior decisions denying petitioners and their lawyers' request for summary judgment, and based on the uncertainty caused by the total absence of any wording concerning an annual guest house license or fee in the Lilydale Assembly's bylaws, rules and regulations, or guest house contract, we feel that Judge Hanlon absolutely made the right decision to deny summary judgment and that there's no just cause to overturn her decision.
Thank you very much. 770, Marguerite Ross versus Village of Fayetteville. Oh, and Justice Greenwood is recused on this matter. Go ahead.
Good morning, Your Honors. John Tantillo on behalf of Petitioner Appellant Marguerite Ross. The primary issue in this appeal is whether or not approvals can be upheld despite a complete lack of supporting findings or even rationale by the approving board. The planning board here issued a negative declaration under seeker, a special use permit, and site plan approval, but the record is entirely devoid of any showing that these approvals were supported by findings that explained the basis of these decisions. There are 3 main reasons why these findings are typically considered essential in administrative reviews like these. First, courts have held time and time again that findings of fact are necessary for the reviewing courts themselves, because without them, it's impossible for the court to determine what the basis of the decision was and whether that basis was rational and legally valid. Second, as pertains to the seeker determination, the entire point of seeker is that the deciding agency has to show that it's considering the environmental impacts of its decisions.
What environmental impacts did they consider? There were various studies that were made, lighting, traffic, noise, etc. They were discussed. There were numerous meetings by the planning board.
There were plenty of studies. The applicant put in a lot of environmental review, but that doesn't satisfy the planning board's obligation. The planning board, when it's performing its seeker review, has to provide a reasoned elaboration of its decision, either a negative declaration or a positive declaration. Here, all we have are the check boxes on the EAF. In the box at the end of the EAF, where the reasoned elaboration typically goes, We just have two paragraphs about why they're not looking at something that DOT is looking at and why they're not looking at something that DEC is looking at. No written explanation for their seeker determination is provided in the EAF or in the negative declaration resolution. When all the board does is check boxes on EAF, that should...
So we're talking about vaunting, form over substance, when in fact the record that I saw had exhaustively outlined the give and take between the agencies reviewing this and the planning board to come to whatever positions that they eventually came to, which indicated no environmental impact. We're talking about taking a building that's already there and reusing it. Is that right?
It's not really in this case, but that's not entirely right. Essentially, that building's going down to the ground. The foundation is going to be kept, and a new building is being built there, and a grocery store will be operated in it. It's currently abandoned.
A smaller footprint, though, I understand.
Much more intense use on a smaller foundation footprint, but a much larger use of the property.
And the record does have a lot of information about the give and take between the various studies and the planning board.
On that point, I think I disagree, Your Honor. The record contains lots of information provided by the applicant. What the record doesn't have is any showing that the planning board looked at that information and used it to make its decisions. The applicant can provide reams and reams and reams of paper when they make their application. They typically do. That doesn't relieve the planning board of its obligation to actually perform the review and reach a conclusion.
So you're just claiming that they didn't list some findings?
I'm claiming they rubber stamped it.
You're not claiming they didn't take a hard look, are you?
Yes, I'm claiming they didn't take a hard look. I'm claiming the lack of a reasonable elaboration means we can't tell that the planning board took a hard look. All we have
Your client was there at every meeting, the 12 meetings, a couple other meetings, the modifications. I'm sure they made various requests that be made in consideration of that. They were there. They listened to it all. They heard it all.
Absolutely. Ms. Ross was at all the meetings. She's a very passionate public participant. And she saw the applicant present lots of information. That, I'm not contesting that the applicant put in a fairly voluminous application. But that alone does not satisfy the requirement that the board actually analyze that information and show in the record that they did.
We can look at the record, as Justice Bannister indicated, a very extensive record, and determine from that they did do all this, but they didn't maybe write down the findings there.
Well, what Your Honor is referring to is, I think, Northwood's argument that in situations where planning board or deciding board doesn't provide written findings or their detailed findings, so the court can search the record and see if their findings are in the record, or see if the basis for their decision is in the record.
There is an extensive record here of that.
There absolutely is an extensive record of documents provided by the applicant. In those cases...
And discussion.
In those, not by the planning board. We provided the court a link to the planning board hearing, and actually, in case the video was taken down, we transcribed it and put it in our petition, too. There's no discussion of these issues by the planning board.
Your indication, again, is they didn't fill out those little findings at the end.
Not those little findings, Your Honor. Respectfully, I think that's diminishing the obligation of these public boards.
I think we have your argument.
Well, I would like to keep going on that just a little bit, Your Honor.
No, in respect to that, I think we have your argument in respect to that. If you have other?
Well, at least back to the seeker point that I was making initially, the distinction between the checkboxes on the EF that we have here and the written reasonable elaboration, the cases that we provide in point 2C of our opening brief go into extensive detail as contrasting what happened here with what courts believe is effective seeker consideration. On what Your Honor was just talking to about, I guess, the public policy behind actually requiring the board to perform the review, I think that's the heart of the case.
I'm going to warn you that you only have a few minutes left, so.
Okay.
If you want to move on to something else, you probably should.
All right. I'll leave that one. I do think there's a lot of meat on the bone there.
No, it's up to you. I'm just telling you how much time you requested, and your time is almost up, so that's fine.
My 15 minutes is almost up? Okay. As far as the special use permit standard goes, I'd like to stress that the Village of Fayetteville adopted a fairly rigorous test here. Zoning Code Section 187-41A3 states, no special use permit shall be granted unless the following findings are made. This is a mandatory conjunctive test. It's not a balancing test like other municipalities have. The Village of Fayetteville said, if these findings aren't made, no permit can be granted. The application of this ordinance is fairly objective. If we don't have these findings here, which we don't, the special use permit cannot have been granted. There are a few counter-arguments that respondents offered. Justice Montour touched on the one offered by Northwood about being able to search the record. In those cases, the distinction between this instance and those cases is when the court searched the record there, they were actually able to find the basis of the planning board's decision, or the basis of the board's decision, not just information that could have supported the decision had they relied on it. We went through those cases in detail in our brief and found references in those decisions about where this court, in particular, found references to what the planning board relied on and why they made their decision. We don't have that here. We have things we could guess that they made their decision based on, but we don't have that statement in the record.
Okay. Do you have anything further?
Yes. FUBU argues that our position is off base because the cases that we cite deal with denials of permits rather than approvals. Initially, there's no authority for that argument. No case has ever made a distinction between the denial and an approval for this point. But even if there had been, an approval requires all the findings to be made. This actually cuts against FUBU because a denial only needs one finding. This approval needs 6. And finally, as to the village's response argument, they claim that the checked boxes in the EAF could somehow satisfy the special use permit finding requirement. They refer to a written special use permit resolution. I'd note that the special use permit resolution that they cite, it's record pages 118 to 120, is a draft. It was never approved. Nothing in the record shows that it was taken up. Nothing in the record shows that it was ever filled out. The one they cite to is not filled out. But even if it had been taken up, the EAF just cannot satisfy the special use permit standards. If it did, you need to do an EAF for every land use decision in the state. If you accepted an EAF in lieu of findings, then you don't need findings anymore for any application.
I think we have it.
Okay. On the 2 more points, Your Honor.
You don't have, you have like 3 minutes left. So.
Okay. On the specifically the comprehensive plan factor, typically in these cases, I have this argument a lot. One party makes one argument about the comprehensive plan, another party makes another one. You can find language supporting each position. Here, the comprehensive plan is uniquely specific as to this property. They have a specific plan and design and even diagram for what the village wants to happen on this parcel. I compared the approved plan with the comprehensive plan at page 36 of our brief. I'm not asking for slavish servitude to the comprehensive plan, as Northwood claims, but the utter silence by the planning board on this factor, when it's frankly the most inconsistent project with a comprehensive plan I've ever seen receive an approval, is the height of arbitrary and capricious conduct. And then just briefly on the open meetings law, Your Honors. The village maintains a high-speed internet connection and has a routinely and regularly updated website. They admit they prepared the materials in advance of the meeting and admit that they declined to post them. The village claims they didn't need to because until the planning board takes the proposed resolutions up, they're privileged or attorney-client work product. This also would subsume the entire provision. All proposed resolutions would be work product and be undisclosable under the open meetings law if that argument was credited. And this is not the instance where we go back to the record and try to find a mistake after the fact. Ms. Ross was at the hearings asking for these documents in advance every time. It's in the transcript, and she was denied these documents.
You got it right.
Right. So based on these, we request the court reverse the trial court below. Thank you.
Thank you.
May it please the court, I'm Brad Hunt from McKinsey Hughes on behalf of the Village of Fayetteville and the Planning Board. I disagree very much with the argument that the Planning Board did not make findings here. And I think it's very instructive to look at the minutes of the meeting in September of 2022 when the seeker resolution was passed, and at the EAF in particular. This is the EAF that's known as the long form, and it takes up 12 pages in the record. And as the minutes reflect, the planning board actually, did not just check boxes. They discussed the EAF and, orally discussed it in a public meeting and completed it in front of the public. And what the document requires the planning board to do is to go through 18 separate areas of potential environmental impact.
And they did that during.
And they did that publicly, and for everyone where there was any possible impact, they went through every single sub-question in great detail. And the whole purpose of the EAF is to make sure that a board does make appropriate findings and doesn't just do a rubber stamp, and they absolutely did that here. And I think then, so if you look at the timeline here, the EAF, they went through that and made the secret resolution in September of 2022. The special permit was then approved 2 months later in November, and the site plan 1 month after that in December of 2022. The special permit requirements are actually a subset of what they had already decided in the EAF. That's the 18-point, incredibly thorough, covers absolutely everything. And so they had already made the required findings for a special permit before they even got to that November meeting.
And when they went through that EAF and checked off that it was maybe small to moderate as far as what the effect might be, was that based upon some of the requests that were made to modify the plan then?
Yeah, absolutely.
So they were very active in working with the developer with respect to this, and the public.
They absolutely were.
Probably Ms.
And
Ross.
absolutely. And, it's not the case that there's simply, hundreds of pages of material submitted by the applicant that the planning board never considered. It's interesting, if you actually just look through the table of contents of the record here, what you'll see is that there's a series of mirroring letters. You get one from the village engineer, John Putnam, and then a response from the applicant's engineer, Matt Naparella, addressing all the issues raised by the village engineer who's working for the planning board on this project. So it was absolutely a collaborative back and forth process in which the...
And we'll look at all that very carefully.
Excellent. Thank you
Do
for
have
that.
anything further?
I would just say, in regards to the open meetings law issue, what the law requires is that resolutions be posted in advance to the extent practicable and if they're scheduled to be discussed. Here, we have an unrebutted affidavit in the record from the village attorney that it wasn't practical. The resolutions weren't even prepared until the day, the day of or the day before the meeting. And in fact, at the meeting in question, the draft resolution was to approve both the special permit and the site plan. They ended up deciding to continue looking at this project that they'd already been looking at for 11 months for another month. So they passed the special permit resolution that evening and then waited 1 more month for further revisions before finally approving the site plan for the project. Thank you.
Good morning, Your Honors. Rick Weber from Bond, Shannon King on behalf of Northwood Real Estate Ventures. I had planned to carry all 4 volumes of the record up here as a display, but the court is well aware that we're dealing with a 4-volume, 1,800-page record.
We have those same copies.
I'm sure you do, Your Honor. Thank you, Justice Bender. It goes without saying, as you might imagine, we join in the argument from Mr. Hunt, the village of Fayetteville. We believe that there was an ample, hard look at everything that went on here. We think Justice Fogel's decision was a very good synopsis of the efforts that the village of Fayetteville took to really get a handle on this project, to determine the potential environmental impacts to this project. The record, and again, each of you have this, I'm not going to read it cover to cover, of course.
Oh, no, you're not.
No, I am not, Your Honor, that is correct. But I do want to note, Justice Montour and Justice Keene, you both, in response to the argument of Ms. Ross' counsel, pointed out how extensive this record was. We had traffic studies. We had studies that...
Again, we're well aware.
Exactly. And so our basic argument lies on that
Is that in the
record.
record, all those studies?
Let the record of this argument reflect the smile that you said that with, Justice Montour. Like the argument that's being made by Ms. Ross, I am pleased to see that they are not making an argument that the developer, Northwood, did not put in extensive evidence. And they're not arguing that Northwood didn't respond to repeated requests for information, both from the planning board and from the public at large. We attended meetings.
Again,
We had
we're
experts and
well
expert
aware of all
reports. That's right. So
You even adjusted what you were going to do based on the information that was exchanged. That was evident in the record.
that is correct. That is correct, Your Honor. And I think,
You listened to what people were telling you.
yes, that's correct. That's correct. And I think the lower court's decision did a very good job of capturing that process. The only other point I'll kind of stress here, I think, Justice Keene, you had issued this. We're talking about a building that has been a long dormant building at the village of Fayetteville. There were earlier proposals that the village took a hard look at and said, no, too big, too much disrupted, too much that'll impact the community. This proposal is a separate proposal. It's a smaller proposal. It disturbs less of it, and it reduces a non-conforming pre-existing building about in half. This is a good thing, Your Honor. So we think the board certainly put the developer through its paces, certainly had ample opportunity for public input. We would urge this court to affirm the lower court's decision. Thank you.
Good morning. My name is Kevin Rowe. I represent the property owner, Fubu Environmental Services. I'm not going to take much of your time. It's been covered. A couple of points I did want to address, though. One is I noticed that Ms. Ross' counsel did not raise the argument about the failure to conduct coordinated review under seeker. I don't know if that's abandoned or not, but regardless, there are no other involved agencies here. The only other agencies involved, not in this technical sense, are DEC and the DOT. And they both have designated their actions as type 2 actions, which require no secret review. Therefore, they're disqualified from being an involved agency. They cannot act as an involved agency. So there is no need to do a coordinated review. The regulations are very specific about that. If there's only one involved agency, that agency is the lead agency. The seeker handbook, which is the definitive guidance by DEC.
But despite the fact that they were not an involved agency, there were suggestions made as far as lane changes or turning lanes and things like that, which were modified and accepted, right?
Yeah, they were interested, what's known as interested agencies.
Right.
So they did weigh in on the project. The DEC has weighed in on the traffic and what improvements are going to be needed. The DEC is handling the brownfields aspect of this, which is type 2. Because it's a whole separate regime. It's not a secret regime that governs brownfields.
I understand that.
Okay, so that's on coordinated review. The other point I wanted to make was just on the comprehensive plan point. I think it would be remarkable if there were a comprehensive plan, an illustration of a concept in a comprehensive plan that bound some landowner forever to that design. And wisely, this comprehensive plan says it doesn't do that. And I quoted on page 19 of my brief an excerpt from the comprehensive plan that says, it does not prescribe exact courses of action because these must be developed with care in response to a wide variety of situations. The zoning code is the document that actually says what is and what is not allowed. And it's the day-to-day decisions of local boards, officials, and citizens that determine what is actually built and what land is preserved. So that rendering of a concept on this property does not preclude the development here. The zoning code allows this development. In fact, allows much more. If you build out to the maximum allowed by the zoning code on the industrial portion of this site, you could have over 500,000 square feet of development. This is about 10% of that. That's all I have, unless you have any questions.
Thank you. 771, in the matter of the estate of Gordon Ewing.
She can still hear us. You can continue.
Thank you, Your Honor. May it please the court, Ed Markarian for the executor Nancy Ewing. Your Honor, this case
Can I
involves...
stop you for a second?
Yes.
Are you both sitting together? Are you both on the same side?
Yes, we are, Your Honor.
Okay, so, oh, and there we have him. Okay, Mr. Vogel. All right, that's what I was going to ask. I know that there was an opponent checked in on this. I'm sorry to interrupt
No,
you.
thank you, Your Honor. Your Honors, this case involves a presumption that a parent who cares for their child does it out of love and affection and not for payment. That presumption must be overcome by clear and convincing evidence. And there are 4 issues here. The first is that the presumption was not overcome in this case. The second point is that the care that was provided was to the daughter, but this is a claim against the daughter's husband's estate. He did not receive the care. The third point is that the proof of damages was not in admissible or competent form. And lastly, I'll address the argument regarding the timing of the husband's estate. So the love and affection presumption, Your Honors, is very important to surrogates court practitioners, and it exists for 2 reasons. Number one, it's the reality. That is why parents care for their children,
So
vice
let's talk
versa.
about that a little bit, if you don't mind.
Sure.
All right, so we have here, a mother who didn't immediately say, daughter, come live with me. She waited till this daughter was penniless and had very few, if any, other options. And then she took her in. And so it didn't appear that love and affection was real immediate or real strong.
I think actually the timing, Your Honor, is that she took her in after the husband died. So that was the timing. And love and affection.
Wasn't she going to be evicted too? There was a rent, as far as
There
rent
was,
not being paid,
yes,
so,
but-
I mean, where was she going to go? I mean, this woman had significant injury.
She did, Your Honor, but that doesn't mean.
Needed regular health.
She does,
care.
but that doesn't mean we don't care for our children out of love and affection. We need to have an agreement saying that I'm going to be paid. There was no agreement here, and it has to be an agreement proven by clear and convincing evidence.
Does the nature of their relationship make any difference? I mean, I know it talks about, but is any mother, any child, I mean, doesn't the record here show they didn't have much of a relationship? And we're dealing with adult children. We're not dealing with teenagers or 20-year-olds. Both are elderly people, really.
It's no different, and this usually comes up, Your Honor, in the flip side, where the child takes care of the parent. So that's always an adult situation there, and it's always presumed that it's done out of love and affection. And I certainly don't mean to minimize what an important thing that is. I mean, many of us have been caregivers. I understand that. But the question is, are we doing it out of love and affection?
Wasn't there a trust from the husband
Yes.
to provide for his wife?
That's not what it said, Your Honor. It said that the trust exists if it can help the wife during her lifetime. This trust.
How could it not? I mean, what was
It did not have any
What was the wife going to do?
It did not have any assets, Your Honor, until long after everyone passed away.
Well,
There
that
were
was
no-
just because the suit, right? I mean,
That's
the
correct, Your
personal
Honor.
injury
Yes.
came through after,
Yes.
and the husband's came after the wife's, which husband and wife were living on the wife's payout, probably.
There were minimal recoveries there. The court below thought that was equitable, Your Honors, but it doesn't change the issue. The issue is whether there was an agreement, and there was no proof of an agreement. In fact, the record is wafer thin. The testimony is 33 pages, most of which is legal argument and objections that were mostly sustained. It boils down to pages 232 to 233 and 241 to 242. At 232, which the court below found instructive, there was a hearsay statement that the wife called the litigation lawyer and he said, you're going to be okay. But that's not an agreement that the mother's not doing it out of love and affection. And at the next page, the mother testified, I believe there was an agreement, but the court did not allow her to testify that there was a meeting of the minds because that would violate the dead man statute and the hearsay rule. So we just have a unilateral statement.
Okay, we have more than that, though, don't we? We have, the intention to set up a trust for her benefit to some degree, okay?
But the husband is entitled to make the same presumption that the law makes, that the daughter would be cared for out of love and affection. If they need to bring in third parties.
It didn't say that. It didn't specify that, except for the fact if the mother takes care of it, and we're not going to provide for that. If it's some outside caregiver, I mean, obviously the mother gave care to her daughter, which was necessary, which was for a period of 6 months. She passed away thereafter.
But the trust said
she was suffering in that regard.
The trust said that if it will benefit my daughter
How would
during.
that benefit the daughter? What's she going to do? Is she going to be evicted from her apartment and I don't have, I can finish. She's going to be evicted from her apartment, live homeless in the street? Is that what the intent of her husband was?
Of course not, Your Honor. Of course
Well,
not.
then
The husband is entitled to assume what the law assumes. And I would like to also go to a second point. Again, this is clear and
But this
convincing.
trust didn't say it's only going to go to your benefit if your mother doesn't swoop in and take the day.
No,
It
it's-
doesn't say that. It's meant to benefit her.
That's not
No
what
matter
it
who
says here.
provided the care.
That's not what it says. Benefit her during her lifetime. There has to be an agreement. There was no agreement. It all comes back to whether there's an agreement. Parents take care of their children out of love and affection. The trust says if it will benefit her during her lifetime. It couldn't. It didn't have
How did it not
assets.
benefit her? How did he know that she was going to pass away within 6 months? How did he know that the settlement would not be made at the time he made that trust? He knew he had money coming in. There was a loan that was being paid off, right?
Correct.
And so they were receiving funds from that loan, from that perceived potential settlement.
I understand.
They were receiving that money, which was to go to the benefit of his wife, correct?
I do not agree with the last part, Your Honor, because if it were to hire a third-party agency, certainly. But there's no reason for it to go and
I
take
think we have that argument.
But let's talk about that third-party agency. I mean, we wouldn't be sitting here at all because there'd be nothing left to fight about if that money went to a third-party agency, okay? But instead, mother did swoop in, and you're saying she had no expectation that she was going to be paid from the husband.
That's right. That's what parents do. So the other thing, Your Honor, that proves that is the timing of when
Did
she
the mother
presented
have the
her.
wherewithal to pay all these things? Or was she using her own savings to do that, whatnot? I mean,
Your Honor, you'll see that the proof on that is that there's very little out of pockets. The biggest component is what she wants to be paid as if she were a private caregiver. She also, the next.
Essentially, but that's what she became when
Right.
she took
Yes,
this
I
woman
understand
in.
that. But would the husband want it to go?
and the surrogate made a decision as far as the rent wasn't going to be something that she could recover from, but the health care services, which would have been paid to a third party, she was entitled to.
I don't agree that she was entitled to. Your
Well,
Honor.
that's what the surrogate said.
That's correct. That's
Right.
correct. I agree with that. I would like to emphasize the timing of the claim. There was no claim made, and the cases have said that if you're going to say that it was not for love and affection, that it was for a compensation agreement, you have to present your claim either during the care recipient's lifetime or shortly thereafter. That was not done. After the probate petition was presented, the mother consented to probate. 14 months goes by. She does not at any time say, I was a caregiver entitled to payment. Then, when judicial settlement comes up, she doesn't claim that she's entitled to payment as a caregiver. After she files a notice of election, that was her theory, and it's dismissed because that's not a valid theory because her daughter had died. 2 more months goes by, and then she claims for the first time that she was entitled to payment under a caregiver agreement. And the cases have said that where you wait, it's not a genuine claim.
Okay.
You really were providing it for love and affection.
Well, but what is she waiting for? She's waiting for some potential source of funding to come about. You know, the settlement, the money to actually take care of these claims.
But she waited till long after that was in place, Your Honor,
Okay,
before
we
she pressed her
understand
claim.
that, okay?
And she didn't present the right claim, and I think that speaks volumes. I think you have the issues. We also think that her proof as to damages was not an admissible form. She's not entitled to be reimbursed for her own rent. I think the judge thought she was entitled to, she was looking to pay for her daughter's rent. That's not what the testimony
And I think the
was.
judge indicated that.
The judge thought it was for the daughter's rent, but actually she wanted reimbursement for her own rent, which is not proper. So we would ask that the court modify. Thank you.
Thank you.
Good morning, Your Honors, and may it please the
Yeah,
court.
Mr. Bo.
No, you're right, go ahead.
Thank you. Good morning, Your Honors. May it please the court. Thomas Migliaccio appearing on behalf of the minor beneficiaries of the estate of Gordon Ewing. I'm here today as a surrogates court practitioner with a fear of what watering down this presumption of love and affection will really do, not just in this case, but in the practice I do every day. We have a case where the mother of Rebecca is putting in a claim, and her only proof was herself, her word of mouth. In her testimony itself, she says that, no, I didn't make her sign anything. I trusted she would do the right thing. She admits there's no agreement. The law is clear, the case law is clear that an agreement needs to be in place when a family member is looking to be compensated for care that they gave, to overcome the presumption of love and affection. This is a slippery slope. If we water down this presumption, yes.
I'm getting this, is that, the claim of these grandchildren should not be disturbed because we have a claim of a sick spouse of somebody. Is that really what you're saying? I mean, you're making all these grand pronouncements of how we're going to change the surrogates court practice, and I'm not seeing it or buying it.
I suppose the bedrock of my argument is the standard is that to overcome this presumption that a family member has given the care out of anything other than love and affection, the standard is clear and convincing, and the evidence we have is not clear and convincing.
Okay, now I could accept that argument, but not that we're going to stand the surrogates court practice on its head because of this case.
Sure, I understand that, but I feel that this case is lowering that standard of clear and convincing. If we're allowing this without meeting that burden, that we'll have siblings that say, oh, well, I cared more for mom than you did.
I think we have your argument on that.
Perfect. Other than that, Mr. Markarian touched well on the privity argument that this is a claim for reimbursement of funds of care given to the daughter, but this is a claim against the estate of the son-in-law. I find that that's out of place here.
Basically, anything we give to the mother will take away from what we give to your client.
Essentially,
and
right.
You don't want us to do that.
That's correct. I mean, it's a testator's intent is paramount in a probate estate. So that's all I have. Thank you.
Thank you. Mr. Rocco?
Good morning, Your Honors, and may it please the court. I think what Mr. Migliaccio just summed up with is really exactly the point. The intention of the testator is paramount. The intention, first and foremost, was to provide a trust for his wife's care and support of a long-term marriage and a long-term relationship. Secondly, Your Honor, I do agree that this case is not going to undo precedent and the presumption that is in surrogate court. It is a presumption, but it is a presumption that can be overcome with clear and convincing evidence. As is clearly articulated in Judge Mosey's decision, the presumption was overcome and was not contradicted in any way by any evidence or any cross-examination by the petitioners in this case. Accordingly, Your Honors, Judge Mosey found that the burden of overcoming the presumption had been met. Accordingly, Your Honor, we believe that it was a thoughtful decision by Judge Mosey, who did not, in fact, accept all of the arguments and all of the claims that were made, but carefully and surgically removed the items that she felt were not supported by clear and convincing evidence. Accordingly, we ask that the ruling remain. Thank you.
Thank you.